Hello, and welcome to the Disability Law Q&A session hosted by me, Martin Willemse. I am a partner and the Western Canada Disability Practice Leader at the firm of Samfiru Tumarkin. We have offices in BC, in Ontario, and in Alberta. We also handle employment matters, which often interlink with disability cases. When I have this discussion about disability question and answers, we also sometimes discuss life insurance, critical illness, as well as travel insurance questions. So welcome and please join. And if you've got any questions, please, you're welcome to type them in and I'll respond to them as they come through. In the COVID era and beyond, we have seen significant increase in mental health disability claims. Recently, I think there was a study, or rather some statistics that came out by one of the most prominent insurance companies, where there was mention made of an increase in mental health claims to the extent of in the 20%. We've always seen lots of disability claims related to mental health illnesses. I think the statistics support this, that mental health disability claims form the biggest portion of disability claims that are filed with insurance companies, be they short-term disability claims or long-term disability claims. And we always have people reach out to us with their long-term or short-term disability claims that have been denied. Here are some issues to consider when you apply for LTD or for STD, meaning short-term or long-term, when your claim has been denied, or rather when you're applying for it. When you submit a claim for a disability benefit, you have to submit 3 documents. The first one is the claimant statement. The second one would be something called an attending physician statement. And the third one is a plan sponsor statement, the document that your employer would submit to the insurance company. When you submit your claim and you complete the employee statement, always remember that you have to explain why it is that you cannot perform the duties of your own occupation. When you submit a claim for LTD or for STD, you're doing it in terms of a policy. And the policy is a document that your employer has negotiated with an insurance company. It is a contract, and the contract has terms, rights, and obligations. Terms would be something where the term total disability is defined. That would mean that you have to prove why it is that you cannot work. Total disability reads, for the most part, it's different with most policies, but in general, it would say something like this. You must have an illness or a condition that prevents you from performing the essential duties of your own occupation. Most policies have 2 definitions. The first one would be the own occupation phase, where you have to prove that you cannot perform the duties of your own occupation for the first 2 years. And others will have it for 1 year or 5 years, but for the vast majority, it's 2 years. After that time, the definition changes. Then you have to prove that you cannot perform the essential duties of any other occupation for which you've got the transferable skills. So when you complete an employee statement or a claimant statement, when you want to apply for disability benefits, you want to make sure that you provide the restrictions and limitations. In other words, if your doctor has described or has diagnosed you with depression, simply stating that you have depression is not going to result in a claim being approved. Many people work with mental health illnesses in place, be it depression or an anxiety disorder. Why is it that you cannot work? You will have to define, as I said before, the restrictions and limitations. These may look like, for example, a person who works as a bank teller. If they have a social anxiety disorder and they cannot deal with the public, they have panic attacks, etc., these need to be defined in the document that you complete. And also, when the doctor completes the attending physician statement, that needs to be detailed as well. In other words, if you have an inability to focus, concentrate, multitask, cannot handle any social interactions, you have panic attacks, you have low motivation, low energy, profound fatigue, issues with your sleep, all of these need to be detailed in the documents that you submit to the insurance company, so that at their end, when they receive these documents, there is an understanding as to why it is that you cannot work in terms of having a mental health illness when many other people do work. And of course, if there were to be a denial on that by the insurance company, you have various options. But if there is a claim that is denied, please get in contact with us, because we will review the claim documents that have been submitted to the insurance company. We will review the policy if it is available, and most importantly, we will review the denial letter and have a discussion with you as to what your options may be in terms of the claim that has been denied. We have a question that has come in from Art Miggs. It says, my cousin has recently been diagnosed with MS, multiple sclerosis, and is trying to go on disability. His insurer is saying that it was pre-existing condition and said it won't be covered. Is this accurate? The first thing that jumps out at me is when the term pre-existing is thrown out. That generally means that when you have been covered for less than 1 year under a disability policy, and you then submit a claim, the insurance company may investigate, or likely will investigate, whether your disability is related to a pre-existing condition. Now, this is very important and sometimes somewhat complex to understand. When I use the phrase pre-existing condition, I'm using it in the context of how that phrase is defined in the policy. Again, it is a contract. In layman's terms, or in general terms, pre-existing condition makes somebody think that, well, it's something that you had in the past. You may have had it before. That doesn't necessarily have the same meaning in a contract. I'll use an example. When you have a person who's been employed since January the 1st of 2022, they have coverage on the same day, as opposed to some people who would have to wait 3 months during a probationary period. In that context, the person has a coverage since January 1 of 2022. They go off work in October of 2022. So in other words, within the first year of having coverage. That triggers what is called the pre-existing condition investigation. Pre-existing condition, as I said before, is a defined term. It depends on each policy how that term is defined, but generally it would have language to the extent that if you've had coverage for a certain period of, or if you've had treatment for a certain period, during a certain period of time in relation to the disabling condition, your claim is excluded. Some policies may say if you had treatment or medical care, or you were taking prescription medication for the disabling condition or something that is related to the disabling condition in the 90 days before you had coverage, your claim is excluded. So going back to Art's question, just because the insurance company states that there is a pre-existing condition denial in place, that does not mean that they are correct. We would have to review the actual clinical records and the term pre-existing condition, what period it covers, because it may be that your cousin may have had some treatment or some investigation that could relate to other things as well, not necessarily to MS. I've seen lots of cases where the MS condition has been used as a pre-existing condition because it may be that your cousin may have had some numbness, or they have been difficulty with speech, or may have had blurry vision. But does that necessarily mean that it relates directly to the MS condition? Not necessarily. So we would want to investigate the policy wording, the medical records, and the basis for the denial, because quite often there is an argument to make that the condition is not pre-existing. A last comment I will make on this point is, in terms of a policy, when you are making a claim for disability benefits, you as the person making the claim has the duty to prove that you are disabled within the meaning of the policy. When an insurance company is denying a claim on a pre-existing condition, the onus, the duty to prove, flips. That means that the insurance company now has the duty to prove that it is a pre-existing condition. Doesn't mean that you don't have to submit evidence to support your position, but it does, the situation does flip a little bit there. And there is an argument then, of course, to make that the insurance company has not abided by their duty to prove that it is in fact a pre-existing condition. We have a question from Daryl Brooks. I was off for 3 months on short-term disability. I was denied my yearly bonus. I was told it was because I took these 3 months off. Can you be penalized for taking the time off? That would be a question I would suggest that you ask during our employment Q&A, because we have employment lawyers speaking about that as well. Our next one will be on Wednesday, on March 27th at 1 p.m. Eastern Standard Time with Samfiru, our founding partner. And that, as I said, will be an employment law question and answer session. We have a question from Shaut. on YouTube, what are the exceptions to the 2-year limitation period when appealing an LTD decision? Okay, so that's a good question, and there are a few things to be said about this. An LTD claim is based on contract. When the claim is denied, there is something called a limitation period that starts to run. The limitation period that I'm referring to is the limitation period within which you have to file a legal claim, a lawsuit, in other words. The question which is asked here is, what are the exceptions to the 2-year limitation period when appealing an LTD decision? A limitation period and an appeal are not the same things. The limitation period refers specifically to the timeline within which you must submit or must file a lawsuit. Generally, it would be 2 years from the date that the claim has been denied. There are various acts in each province. Each province has its own act that defines when the limitation period starts to run. In BC, for example, the limitation period begins to run from the date that you knew or to have known about the denial or that you had a cause of action. It may be from the date that the insurance company denied the claim, in other words, from the date of the denial letter. If benefits had been paid, 2 years from the date the next benefit would have had to be paid. And the insurance company also has a duty to advise you that the limitation period begins to run and what it is. If the insurance company does not advise you of the limitation period that begins to run, then there's an argument that the limitation period never began to run. So it really is fact-specific and province-specific as to when it starts to run. But I would suggest, if there is a concern with respect to a limitation period, that you get in touch with us as soon as possible, because every day that goes by, there may have been something that could have been done. But there are certain arguments that can be made. Other policies will have something which is called a rolling limitation period, but it is specific to the language in the policy, and we would have to consider what that policy is. We have a question from Daniel Gebremichael. After W sent me to school and graduated, found a job within the province and moved, but WCB denied me relocation support. Can they? We do not handle WCB cases. You're welcome to reach out to the lawyer referral service in your province, and they may be able to refer you to a lawyer who handles WorkSafe BC claims. Our focus is on disability claims, critical illness claims, life insurance claims, mortgage claims, and travel insurance claims funded by employers or private insurance companies. We have a question from Trent on YouTube. Currently on LTD, but my insurer wants me to see an occupational therapist to set up a return to work plan. I'm not ready for that, and my doctor said I'm not ready either. What can I do about this? Remember when I said policies or contracts? Contracts in these policy terms may provide that there is a rehabilitation clause. There may also be a cooperation clause, which will require that you participate in rehabilitation programs, or that you provide cooperation in whatever the insurance company is suggesting on a reasonable basis in terms of information and participation in programs. This is a difficult one because the insurance company, if you do not comply with this request by cooperating with the occupational therapist, may say that you are breaching the terms of the policy and they may deny you. In a situation like this, especially if your doctor is not agreeing, I would suggest that the doctor writes a letter setting out the reasons why you are not in a position to participate in a program with an occupational therapist. The doctor would have to detail, as I said, the reasons why, the risks, because there may be, I will use an example, if somebody has significant social anxiety and are required to attend a facility where they have to participate in rehab, the doctor may say, well, they're not ready to do that because leaving the house will increase the anxiety situation and it may lead to an exacerbation, in other words, a worsening of the condition, which would not be advisable. So your doctor, in this case, hopefully will be the advocate to advise why it is inappropriate for you to participate in a rehab program with the occupational therapist at this time. The doctor will have to give reasons why, submit that to the insurance company, and if they still insist on you participating in the program, reach out to us and we can consider what options there may be available to you at that time. We have a question from Mina. I have developed a bowel condition after having some cancer removed. My doctor has said he thinks I won't be able to return to work at all, but my insurer has said I don't have sufficient evidence, despite listing my condition multiple times. How should I handle this? I'm sorry, Mina, that you're going through this. This is a tough situation for you. So if you say that the insurance company has denied your claim because you do not have sufficient evidence in the context of having a bowel condition after having cancer removed, remember what I said before. A disability claim is focused on restrictions and limitations. So other than just providing the diagnosis, we would have to provide evidence, and the doctor has to, and you have to, as to why it is. What are the restrictions and the limitations that would prevent you from performing the essential duties of your occupation? So in the context of the insurance company having already denied your claim, you have an option to appeal, or you have an option to file a lawsuit. In other words, a legal claim. As soon as a claim is denied, I strongly advise you to contact our firm to get a free consultation in order to assess why the decision was made and what your options are, which, as I said, may be a legal claim. When we get involved in cases where they have been denied, all communications come through us. You no longer communicate with the insurance company and you no longer have to deal with them. We take over all communications. So I strongly advise you, Mina, to contact us and we can have a look at why this claim was denied and what your options are so that you are in a position where you can make an informed decision. We have a question from Chris on Facebook. I'm currently on leave for anxiety and depression disorder. My sister-in-law is getting married in the spring and I'm worried about attending the wedding. It is in another province. Should I inform my insurer? Can they cut me off for attending? Two things to say on that question. The first one is, I often get asked this: can I travel if I am on disability? In other words, if I'm receiving disability benefits, will the insurance company cut me off simply because of the fact that I am traveling out of province? The answer to that is, the policy, remember what I said before, has terms and conditions. Some insurance policies will have a term that you are not allowed to leave the country for a certain period of time, or some may say that you have to get the insurance companies, you have to inform them, and they have to be advised of the reason, I suppose, and they can consider whether they will agree. In other words, that they will not terminate your benefits. I have never seen a policy where the insurance companies will say that they are in a position to deny you travel to another province. I've never seen a policy that prevents travel to another province. Out of country ones, yes. So they may be, if you leave the country for more than 30 days, you have to advise the insurance company. Or if you travel for more than 30 days, you may lose your benefits. It may be a different time frame, but there are other policies that are completely silent on the issue. I think the bigger issue here, though, is you're on disability at the moment for anxiety and depression. I'm not saying that you cannot travel, but remember, if you've made a claim to the insurer and you've advised the insurer of certain restrictions, limitations that you have, they will look at what you do in your activities of daily living to see whether what you're saying to the insurer in terms of why you cannot work, what your restrictions and limitations are, would that be consistent with what you're actually doing? It may be that your doctor would have said to you, it is advisable that you travel to attend the wedding. It will be a positive experience. You will be with family. It will help you in terms of your medical condition, having anxiety and depression. But again, be careful. I would have a discussion with the doctor about this as well. If the insurer asks you this question and they found out later that you did not tell them, it may be an issue because they will always look at, especially mental health claims, at credibility issues. In other words, is what the person is saying to the insurance company consistent with what they are doing in their actual lives? We have the question from Erin on YouTube. She says, I'm thinking about renting out my condo and moving in with my family because money is tight while I am on LTD. Would this be considered income and impact my LTD payments? This is a great question, and it's something that comes up quite often. I've had similar questions with people would say to me, I've just received an inheritance. Is that an offset? Or I sold some shares that I was trading on the stock market. Is that income? Would that be an offset? So If in Erin's situation, she is thinking about renting out her condo because she probably can no longer afford the payments, so it's becoming more difficult financially, moving into her parents so that she can rent out the condo. Now, a disability policy has what is called offsets. It provides for certain things that can be deducted from your benefit amount. Generally, those would be related to employment income. In other words, CPP disability benefits is a direct offset. WCB benefits related to the disability would be a direct offset. Then there are some things called indirect offsets, which may be if you got CPP disability benefits for a dependent, or if there were to be some benefits you would receive as part of a salary continuation. It really depends on the wording of the policy. But in this case, renting out your condo is not employment income. It would be the same if you were living in your house and you had a basement suite and you were renting out the basement suite for income. Would that be considered to be an offset under the policy? My position on that would be no, it wouldn't be. Obviously, we would have to look at the wording of the policy, but in a general sense, employment income form offsets. In other words, offsets that you could get from other benefit sources related to your disability. The situation would be different, and we've had this discussion before, if you had been renting out a number of condos that you own as a business, because that would sense to be business income, which may be an offset. Or if you had a bunch of condos that you are renting out and you are maintaining them, you're acting as a property manager by communicating with the tenants, collecting the rent, doing the bookwork, performing maintenance, things like that. That would be more problematic. Ashley Burrows says, my mother has been dealing with an appeal for her LTD for the last year. Her insurer keeps saying she has insufficient evidence, but no details on what they need specifically. What should she provide? Ashley, if your mother has been dealing with the insurance company for a year, and they're still saying that they have insufficient evidence to make a decision to approve the claim, I think the time has come to reach out to our firm to have a discussion with one of the lawyers to see what your mother's options are. The reason why I say that is it's been a year. You can go to disabilityrights.ca, as you can see on the screen there, to submit your questions to us and to contact us. My concern is that it has been 1 year that your mother has not had benefits paid, so no income coming in. If it has taken this long, I'm sure when you say they keep saying that they require further evidence and that the evidence that have been submitted is insufficient, that means that there has been a number of appeals. I'm concerned that the limitation period is going to run out. It is 2 years. She's already been with this for a year. And clearly the insurance company is not accepting the evidence that have been submitted to this point. And every time you submit another appeal, further evidence is provided, and there is nothing that is being done at the end of the insurance company. Again, contact us. We will look at the claim. We will look at the medical evidence. We will look at the policy, and we will look at the denial letter and advise your mother as to what she can do, which one of the options will be to pursue a legal claim. And at this point, considering that the appeals have been unsuccessful, I seriously think that this is the option that your mother should consider. So have your mother contact us as soon as possible. We have a question from Arthur, which was submitted through Facebook. I was recently in a serious car accident and suffered a brain injury. I will have long-term impairment issues and am about to start rehabilitation. When should I speak with a lawyer about the accident? Do I need separate lawyers for accident insurance and LTD? I know that there are lawyers who handle both. At our firm, we do have lawyers who handle personal injury claims. We also have lawyers who handle LTD claims. So it depends on where things are at for you, but I think it's never too late to have a consultation, because we do offer free consultations, be it with respect to employment matters, long-term disability matters, or personal injury matters like motor vehicle accidents. Listening to what Arthur has said, he was in a serious car accident and he suffered a brain injury, which obviously is significant and serious. I would suggest that this is the time right now to reach out and have a lawyer at least consider what your claim is about, why it is if your claim has been denied, why it was denied, so we can consider what your options are. You want to get information in place as soon as possible so you know how to navigate the claim, and if there were to be a denial, where you should turn. Ashley mentions that it has been extremely stressful for her mom. I fully understand that because she hasn't been paid for at least a year. And that is not correct. The insurance company has what is called a duty to properly adjudicate the claim. They have a duty of good faith. When you're dealing with an insurance company under a disability policy that has been negotiated either through the employer or that you may have gone out and purchased by yourself, remember, these are what is called peace of mind contracts. You purchase those contracts, or your employer purchased those contracts as an employee benefit, with the goal that it provides you peace of mind that if you were to become sick, or if you become ill or injured, and you're unable to work, that the insurance company will step in and abide by their obligations under that peace of mind contract and pay benefits to you. That is what those contracts are for. And in a situation like with Ashley's mother, it's not happening. She hasn't received benefits for over a year. And that is a serious concern because clearly the insurance company, depending on the facts here, but it sounds like lots of evidence have been submitted, the insurance company is not abiding by their obligations under the contract and under the common law obligations of it being a peace of mind contract. We have the question from Darrow, which was submitted through YouTube. I have been struggling with fibromyalgia for a while now, and my insurer has not supported my claim. Do people typically get coverage for this? It seems very difficult just to get a diagnosis. This is such a good question, Darrow, and thank you for submitting it. Disability policies, and again, I always use this in a general sense because there are a few, not many, there are a few that may prevent you from having coverage for certain conditions, and fibromyalgia may be one of them, but they are so scarce. Practically all of them, other than these few, will provide coverage if you have an illness or a condition that prevents you from performing the duties of your own occupation. What does that mean? It means that if you have some medical condition that prevents you from performing your duties, you should have coverage. In other words, you should be paid. So when you ask the question, do people typically get coverage for this? I'm assuming you're asking, do people typically get their benefits approved? Some do and some don't. It depends on the insurance company. It depends on the case manager. It depends on the strength of the claim, the evidence that has been submitted. And frankly, you cannot say which one is going to be approved and which one is not. I agree that fibromyalgia has been deemed to be somewhat of a controversial diagnosis. Insurance companies have looked at it quite often from a cynical standpoint, but that does not mean that you are not disabled just because you have that diagnosis. You are correct. It is often difficult to get a diagnosis, but I would want to make this point, and I want you to understand this clearly. A disability claim is about functional impairment. The diagnosis is important, but it's not the most important thing. Functional impairment is the most important thing. If you have support from your doctor that you cannot work because of the restrictions and limitations that you have, be it as a result of fibromyalgia, chronic fatigue, or chronic pain, or whatever the condition is, the focus is, why can you not work? What are the restrictions? What are the limitations? That is what the insurance company has to look at, and that is the evidence that you have to submit. I have seen fibromyalgia cases approved, but then later denied. I've seen fibromyalgia cases that are denied from the outset. I've handled lots, and not just me, people in my firm have handled lots of disability cases where the person was diagnosed with fibromyalgia, which often goes with other conditions like depression or chronic fatigue or anxiety. As you know, with fibro, you may have brain fog, you may have diffuse pain, you may have mood disorders, you cannot focus, there's cognitive impairment. All of these would be deemed to be restrictions and limitations. And these are the reasons why you may not be able to work. So again, if the insurance company denied your claim based on the fact that you have fibromyalgia or based on the fact that you have insufficient medical evidence to support your claim, reach out to us because we are very familiar with these conditions, which are generally termed invisible conditions. For example, fibromyalgia, chronic fatigue, and anxiety and depressive disorders, or any other psychiatric disorder. You can contact us to find out more at disabilityrights.ca, and you can email us your questions at help@disabilityrights.ca. That concludes our session for today. Thank you for joining, and thank you for submitting these questions. Our next Q&A session will be on Wednesday with Lior Samfiru, and it will be an employment Q&A at 1 p.m. Eastern Standard Time. Thank you again for joining us, and hope to see you in the future when we do another disability rights Q&A. Thank you.